What makes something a contract? We make lots of small contracts every day. When you buy a sandwich for lunch, you make a contract. When you park your car in a parking lot, you make a contract. Sometimes you get a receipt for your purchase or service. Is the receipt the contract? Is the small print on it the contract? This first lesson will give you some answers to those questions, or at least it will give you the right questions to ask to answer the question, is it a contract? As shorthand, I'll use the letter K to mean contracts. Contract law is civil law as opposed to criminal law. It is mostly state law in the United States, and it is part of a system of what's called common law, which means that the law can be developed by court decisions as well as by statutes passed by legislatures. There is another area of the law that's in between contract law and personal injury law or tort law that is like contract law because it begins with the giving of a benefit by one person to another in circumstances where justice requires that they be compensated for that benefit. That area is called the law of restitution. However, contract law is different because contracts always begin with a voluntary promise by one party to provide some benefit to another party. If there's no promise, there's no contract. Now, the party receiving the promise must either make a return promise of some benefit, which is an acceptance, and the benefit is called consideration, or in certain circumstances, the party receiving the first promise can rely on it to their detriment and thereby create a contract. The parties must be adults usually and not mentally ill, and what they promise to do must be legally permissible. And how do we know that they've made a promise that they intended to be enforced by law, which is what a contract is, a promise enforceable by law? Well, in the old days, we let them testify, the courts allowed them to testify as to what they intended by their words or actions. But now the test of whether what someone said or did was intended as a contract promise is objective. It's judged by what a reasonable third person would think that the party intended. To distinguish the first promise from the return promise, we call the first promise in a contract the offer, and it has proposed terms and a proposed method of response. The response to the offer, if it meets the terms of the offer, is called the acceptance. And as we said before, a contract promise must have an intention by the offeror to create a legal duty, to perform the promise. It must have a specific offeree, and its proposed terms must be clear and enforceable by a court. And again, we judge the intention of the offeror objectively by what a reasonable third person would think it meant, not what the speaker or the actor himself or herself says they meant. For example, If Jane tells her friend Mary, hey, you know that new restaurant that just opened? Well, let's go to that restaurant. Lunch is on me. And Mary shows up when Jane says to meet her, but Jane doesn't show up. Now, is that a breach of a contract for Jane to say lunch was on me? Well, no, according to the rules we just said, because it's very unlikely, judged by what a third person would consider Jane's intent, that saying lunch is on me at the new restaurant was intended to create a legal duty. But what if Jane owed Mary $200? And this was a very expensive restaurant where the meal might cost $200. In that case, if Jane doesn't show up, Mary might say, well, this lunch was supposed to pay off Jane's debt to me. And by not paying off the debt, then Jane breached a contract. That's much more likely because the circumstances would indicate that Jane intended her promise to be enforced by law. As mentioned before, the person to whom an offer is made must be specifically identifiable. Therefore, advertisements to the public are not offers and cannot be accepted by anyone who sees them as the acceptance of a contract. Ads are merely invitations for offers from the readers to the advertisers. They're inviting you to go into a store where they have advertised that their goods are available and make an offer to buy them. Again, an offer must have clear and definite terms that a judge will understand how to enforce in a breach of contract lawsuit. Sometimes all the terms that are necessary to make a contract offer clear do not have to be actually spelled out in the contract itself, especially if it is a sale of goods contract under the Uniform Commercial Code Article 2, which is a uniform law in all of the United States, each individual state, because sale of goods contracts are so common and have so many normal and usual terms. In that case, a court can imply into the contract what's called trade usage, trade custom, and the party's course of dealing or the party's course of performance to fill in the blanks for terms of the contract that are not spelled out. A contract offer is not open forever. There's a duration, a time limit for acceptance of the offer, which is the time limit either specified in the offer itself, or if there's no time limit specified in the offer, the law says it's a reasonable time based on the facts. If an offer is not accepted within the time specified or the reasonable time implied by the law, it expires. And any attempt to accept the offer after it expires becomes a counter offer. Also, if there's an acceptance before the offer expires, but it is with different terms, this is also a counter offer. And the effect of that type of counter offer, an acceptance with different terms, is that it terminates the first offeree's power to accept the original offer. Offers can be revoked by the offeror, meaning they can be withdrawn at any time prior to acceptance by the offeree, unless the offer's terms prevent revocation, or for a sale of goods offer, the Uniform Commercial Code rules prevent the offer's revocation. For example, if Bill makes an offer to buy John's car, and John says, well, I like that offer, but let's change this price or these conditions in the offer. That is not an acceptance of the offer. That is a counteroffer, and Bill can now say his original offer has ended. In my book, Everyone's Guide to Electronic Contracts, I discuss these rules in Chapter 1, What is a Contract? And Chapter 2 is also relevant in terms of talking about common law, state law, federal law of contracts, international law of contracts. Chapter 3 talks about restitution or unjust enrichment, that area between contracts and torts. And Chapter 4 gets into the details that I'll get into in Lesson 2 about the requirements for a contract beyond those we've talked about in Lesson 1.